if you're going to use the legitimate interest processing condition, you've got to have a legitimate interest. And hopefully this demonstrates that the way we operate, the role we play, the things we promote responsible lending, protecting people from bad debt. We also do a lot of work in the anti-fraud space. I think gives us a legitimate interest, a basis to start from.
So lots of talk about what we do, and pretty much in the UK, because we are UK lawyers, so it's pretty much what we know. But it's not a UK industry. So for those of you that are operating across the EU and thinking, well, why are we listening to you? You're pretty much talking about UK examples all the time. We're not just a UK industry. Credit bureaus operate across the EU. I think we hit 27 of the 28 member states, or a large number. So it is something that we do have to comply with data protection legislation across the piece. It is different, though, country to country. So some of your industries, it may be that you do the same thing again and again, cookie cutter across the EU. It isn't the same in our industry. We have different ownership models set up. We have different data uses in different countries. There are different data providers in different countries. And part of the reason for that is that we do have to comply with a very different legal landscape nationally. We have to look at the local rules and regulations, and each bureau will be set up to comply with them. Now, part of the regulation, the benefit being promoted of it, is that we're going to move to a regulation which will get rid of these 28 different data protection laws. All really good. It will ensure harmonisation. But in our world, that won't be a deciding factor. It won't say, well, we can become one harmonised across the EU, because there are many other different laws and requirements that are set up, and many different cultural aspects in how you deal with credit in country that do and will stay the same different member state to member state. So this does have an impact with how we look at data protection regulation. We are bound by other laws. There will be bureaus in countries which are set up to comply with laws around how they are able to provide our services. Poland, for example, has banking laws that set out very specifically how they can provide their services. Where there are banking laws and other consumer credit laws, it may be that legitimate interests is not so important because there is a legal ground for the processing, so you don't need to look any further. But in other countries, there is no legal ground that says that a credit bureau can provide the services it does, and this is where legitimate interest becomes all the more important.
So by anybody's definition, we have got a lot of data. So here's some of the records as they exist in our consumer bureau in the UK at the moment. The last count, 1,500 million data records. Couple of points to note on this. The first is that this is not some large, unstructured, hastily assembled big data database. This has been assembled over many years. It's a database in which data generates data, so the links between addresses, name matching and so forth is very important within there. And it's worked hard. It's not, again, some of the databases we talk to some of our clients about where people have got a lot of data but don't really know what to do with it. This database is sweated by the minute. It's being hit thousands of times, an hour at times, and it's worked very hard. The second thing is, without getting into a lot of technical detail, we are undoubtedly a data controller of that database. We are probably a controller in common with the people who supply data to us and to whom we provide. It gets quite complicated, but for these purposes, we wouldn't ever try and say we're just a processor. We don't need to think about processing conditions. We're a controller, and we do. So the big myth about credit referencing, and it is a myth which if I achieve anything in this job, I will try and change the perception of this in this country, because it is so poorly understood, including by a lot of people who work in the industry and really should know better. And I think the reason for it is because of this perception that consent is better than anything else. And so there is a feeling that, I talk to people at competitors, talk to people at clients. We've been doing a lot of work since the regulation was published to try to turn this perception around, because if the regulation, certain provisions go in a certain way, we will really, as an industry, need to get this better. But there's this perception that in the UK, it's based on some special sort of consent that you have to give. Now, that can't possibly be consent in my book. I think it's probably confused as well by the fact that if you sign a paper application for a credit product, you will sign something against something which says stuff about what's going to happen to your data, but it isn't consent. And there's a couple of reasons for that. So you could probably make consent work in some situations with regard to what credit reference agencies do, but you can't make it work where we hold negative data about people. So we hold a lot of positive data, so if you meet your obligations, that will be recorded, and that will be important. It's particularly important to the financially excluded. If you haven't got a credit record, however well off you are, you're unlikely to get credit in this country. Positive data is very important. But negative data where you have not fulfilled your obligations, obviously you can't rely on consent for that, when consent can be withdrawn at any time, and consent should be freely given. So it just doesn't work. But as I say, there is a lot of misunderstanding about that. People talk about it in the wrong terms, but we have got to get used in our industry to talking about legitimate interest, because that is actually, in my mind, it could be used for the whole of what we do. Certainly is the basis of what we do for negative data processing.